Good morning, good afternoon, and good night. Welcome everyone to this week's Law Science event. I am Vanessa Villanueva. I am a JSC candidate at the University of Illinois, and I will be the moderator for this session. So before introducing today's speaker, let me briefly introduce the Law Science Project. Law Science is an academic initiative coordinated by a group of JSC candidates who share the same belief in legal methodologies, which are often understood as a discipline distinct from hard sciences and traditionally consisting of doctrinal analysis and normative questions. So through this series of interdisciplinary talks, we aim to show that legal research can be improved and benefit from scientific methodologies that provide systematic ways to approach questions and deliver falsifiable claims. If you want to learn more about the Law Science Project, please visit our website and join our mailing list. Now, one of the coordinators will drop the links in the chat so that you can join the project. I also would like to bring to your attention the ongoing call partnered with the WINNER, which is the World Interdisciplinary Network for Institutional Research. I'm part of the Young Scholars Committee, and Law Science is a partner of WINNER. This call is directed to doctoral candidates in different disciplines, and these candidates will receive meaningful feedback from senior scholars. You can present your papers, the abstract of your papers, or maybe your dissertations. Again, if you're interested in having more information, please subscribe to the project. So now I would like to introduce our coordinators. First of all, we have Simonson, which is an SJD at Indiana University Moore School of Law and co-founder of this initiative. There is Patrick Chunchawan, who is a JSC candidate from the law school at the University of Chicago. And finally, we have Daniel Hifke, who is a JSC candidate at Cornell Law School. We also have representatives of JSDs and JSPs programs from the University of California at Berkeley, University of Virginia, and we are reaching also other institutions in the US. So we finally, let me introduce today's talk speaker, which I'm very excited about. We are very honored today to have Dr. Sara. She is assistant professor at Dalhousie University Schulich School of Law, where she teaches property law, private international law, and critical perspectives on law. She has 3 prestigious doctoral fellowships, in addition to previously teaching at other law schools, such as both the Peter Allard School of Law at the University of British Columbia, where she taught transnational law and cultural law, and the Osgood Hall Law School. Dr. Ross completed her articles at the law clerk to the Honorable Justice Luc Martineau at the Federal Court, and became a lawyer, a member of the bar in Ontario in 2013. She is an executive board member of the Canadian Law Society Association, vice president, Canadian Association of Law Teachers, treasurer, and co-editor-in-chief of the peer-reviewed scholarly journal, Canadian Legal Institution Legal Education Annual Review. In 2021, she was named one of the top 25 most influential lawyers in Canada by Canadian Lawyer Magazine, and was a recipient of the Rising Stars Leading Lawyers Under 40 award for Lexperts Magazine's top Canadian lawyers under 40. So without further ado, I will introduce her lecture. The topic is extremely interesting: interdisciplinary approaches to law and culture in the city, sociolegal methodologies, institutional ethnography, legal anthropology, and comparativism. Please, the floor is yours.
Thank you. Thanks very much for that kind introduction, and for inviting me here to speak with everyone. This is quite the delight for me. So today, what I thought I would do is I'll focus on some of the approaches, as you can see in the lengthy title, and methods that I take in my research. So comparative approaches, namely a transsystemic approach, and urban legal anthropology, and specifically the tools that I find useful from institutional ethnography. But first, what I'll do is I'll situate these methodologies a little bit in terms of my own research, because how and why I apply these methodologies, these tools, is really directly linked to what my research, most of it, focuses on. Okay, so I'll just advance the slide here. There we go. Okay. So before that, though, what I'd like to do just briefly is to emphasize how really important I think it is that we talk about methodologies and how we approach legal research. And oftentimes when we're doing interdisciplinary work, a criticism from other disciplines, when we draw on some of the methodological tools that might be traditionally situated within their disciplines, so interviews, for example, this use can be sometimes criticized for a lack of rigorous engagement. But much of this, in my experience, has to do with a lack in the legal context of writing up the methodological choices that we've made, how these choices have been made, why, and how they've been applied. So this kind of writing up, kind of a thoughtful transparency, is often more common or expected, right, within these other disciplines that we might be drawing methodological tools from. So this thinking through of methodologies is very important in the first place, but it can also be important to include some of these thoughts, decisions in what we actually end up writing and how we ultimately present or publish our research in law. And secondly, whether or not we explicitly decide in legal research to utilize a methodology, there inevitably is some sort of methodological choice that we're all really making in the end. So just a little story: when I was doing my PhD in law, and specifically when I was turning my mind to writing the methods section of my dissertation, I remember trying to convince some of my other PhD colleagues to join a conference panel that I was organizing on this subject of methodologies. And some of the responses that I received was that, no, they didn't have a methodology that they were using. They weren't drawing on a methodology. Methods didn't really apply to their work because they weren't explicitly doing legal research, interdisciplinary legal research, or legal research that engaged with the social sciences. But something that I had noticed, and the reason why I wanted to get them all together to talk about methods in the first place, is that everyone ultimately approaches research in a certain way and ultimately applies some kind of method. So everyone can really benefit from thinking through what kind of choices, what kind of methodology that they're either consciously applying, or maybe just drawing on without specifically making a conscious choice or a decision to do so. So one of my, for example, one of my colleagues was involved in this very large scale, massive coding project, reading through hundreds of legal cases from different jurisdictions around the world, comparing them across these jurisdictions. And even though she was adamant, unlike someone like me with kind of a conscious choice about methodologies, a background in social sciences and anthropology, she was adamant that no, she wasn't applying any methodologies. But, she actually really was. She was drawing on comparative law, quantitative methods, textual analysis, and so on. So my point here is that there's really such great value in thinking through how we are engaging with research, spelling it out, deconstructing the approaches or the inclinations we have, because we all have an approach. We all have a method. And thinking consciously about this, delineating what we're doing and why, can help build the replicability, the transparency within the research and the writing up of this research that we're doing. So next, what do I research? Again, I'll talk a little bit about this now to give a sense of why the methods I'll talk about next work well for me and work well for my research areas. So I study broadly cities, and part of my background that kind of informs this is archaeology as well as anthropology. So on the one hand, I'm interested in the built structures of cities, buildings, parks, spaces, the redevelopment, development of these built structures and areas, and also the inanimate things in cities. So garbage, refuse that's created in cities, cultural objects. And on the other hand, I'm also even really more interested in how people move about the city, move about these spaces, how they interact with or can or cannot access the built spaces of cities, what they can or can't do in these spaces, and why. And how all of this is ultimately shaped by law, whether this is local law through property law, planning law, bylaws, or international law. And I'm also interested in how these in-person interactions are also reflected virtually in online spaces, virtual spaces. So in looking at this, all of this, and in applying the tools of sociolegal methodologies and comparative law that I'll get into more next, what I'm interested in is teasing out the mechanics of inequality that can take place in everyday life and ultimately shape people's experience of the city, their life in the city. And so the next layer to this, and much of where the comparative lens I'll get into comes into play, is that I look at international frameworks for sustainable urban development, soft law for the right to culture, for example, in the city. And I look at whether or not, or to what extent, these blueprints, these soft law frameworks are present at the local level, reflected at the local level, and how, if these international frameworks are desirable, then how and where they might be localized within the individual context of a city or, a part of a city. So now we'll get into some methods that I use, and I'll give some illustrations of what this has looked like for me in some of the projects I've worked on. So what are these approaches that can be taken and how? So as I mentioned before, methodology, these are a large focus of how I approach a research project. Broadly, my methods are situated within, the interdisciplinary sociolegal realm, and they also involve quite a bit of comparative work, and as well as in-person field work. So first, I'm going to explain a bit more about what I mean when I say comparative approach to legal research, because comparative law isn't exactly what I do, but it's what much of my approach might be categorized or potentially understood as. But what has really informed my approach here over the years was my initial training in law school. And so my legal training is in both common law as well as civil law. So I have dual degrees, but more specifically, this was within the transsystemic tradition that was pioneered by McGill University's Faculty of Law in Montreal. So what does this mean? What does this word transsystemia mean? So for those of you who had the time, by no means necessary, but I included a short excerpt of the Strauss piece to read a bit as a backgrounder here. The article itself is largely about legal education, as you probably noticed, but it gives a good description of what what a transsystemic approach looks like, the experience of it when one's learning law through that approach. So McGill Law is in Montreal, which is in Quebec. And the reason why this is important is that Quebec is unique in Canada as a mixed jurisdiction province where we have both the common law tradition and the civil law tradition happening together at the same time. So common law here broadly exists where public legal matters are implicated, and the civil law broadly governs all matters of private law, so contracts, torts, known as extra-contractual obligations there, family law, property law, conflicts of law, or private international law. And so for those of you who are familiar with civilian systems or civil law systems, there is a civil code, of course, a Quebec Civil Code. And there is attached to this within the other law faculties in Quebec, a different way that one would generally learn about civil law than one would in a common law system in a law school in the rest of Canada, based around precedent and so on. And now, by contrast, though, at McGill, within this transsystemic approach, and I should say that since my time there, this transsystemic approach also now includes Indigenous legal traditions and approaches through which these legal systems might be taught and learned. But how law is taught at McGill in this transsystemic way is first introduced through the structure of broader legal problems, theories, universal debates. You know, as you might experience someone who isn't trained in law would approach you as a lawyer with a problem, you know, free from legal terms or concepts, but really just, here's my problem. So the transsystemic approach focuses on the commonalities that underlie different legal traditions, the mechanics of the structure that goes into what we understand of these dominant legal systems, statutes, case law, civil codes. These textual elements are decentered, so they're taught later on. And even when these more kind of traditional pieces of legal material that structure legal systems that we utilize are introduced, oftentimes these materials are drawn from entirely different jurisdictions around the world, outside of Canada, or even drawn from international law. So as you can see, this is quite different from a truly comparative approach, but I've found it's very helpful for looking at issues that underpin existing laws that govern the daily reality in cities. So thinking through these problems, it's helpful, and working to find suggestions or solutions that are a bit outside of what might be conventionally thought of as available options given in a given legal framework within a certain place, thinking of tweaks that might be made to existing laws or transposing different ways of understanding a legal problem into understanding or addressing a given gap in law or unequal outcome and so on. So to sum things up, transsystemic methodology, as opposed to a purely comparativist approach or methodology, really seeks to reach into, look underneath legal frameworks and legal systems, which again is helpful for digging into the mechanics of inequality and how these play out in everyday lives and spaces in the city. Seeing how law, you know, intersects and shapes these, but in a way that may be less obvious than if one were to look directly at the typical kinds of structures and materials that are usually turned to when we are looking for, thinking about quote unquote law. So now I'll give a bit of an example of what this might look like in the urban context. So one of my recent projects narrowed in on processes of displacement in cities for cultural venues, in particular music venues, performance venues, as well as specific areas in cities with a concentration of cultural venues, arts communities, performance spaces, and where these were being displaced, and largely through what one might loosely term gentrification processes, more specifically land value assessments, triple net leases. Again, don't worry about this, details for another day, run evictions, a few other elements. But one of the hoped outcomes at the end of the day, or deliverables, you might say, was to think about how to curb or avoid displacement in these situations. So displacement via these processes was the identified problem here. And then part of the next step for me involved thinking about what might be desired within a situation where displacement could be avoided for these particular communities or buildings. So what did they want? What would that look like? And then subsequently identifying a legal mechanism or a structure or a tweak to an existing available legal concept that could accomplish this, which of course is going to look different depending on the legal system. But starting with the problem enabled identifying what various tools might look like potentially within different legal systems, even though they wouldn't necessarily be directly comparable or accomplish precisely the same thing in the same way. And so, for example, and I won't go too far into the details here, because I do want to cover more ground in terms of methodology specifically, but some of the comparative tools that I identified during this work to give you a sense. So at the international level, the human right to culture in the city that can be located in international blueprints for sustainable urban development and redevelopment. At the level of urban or municipal planning law, the community land trust structure has been successfully used in some cases in some jurisdictions to maintain affordable housing areas. And more specifically, in other jurisdictions, cultural land trusts have been adapted, successfully deployed. That's just some more on land trusts there. And more broadly, if we think about common law terms, we have, of course, this trust structure that legally enables new legal tools like the community or cultural land trust to exist. And then in civil law, specifically within the civil law of Quebec, we have somewhat of a trust structure. A Quebec civilian will tell you absolutely no, there are no trusts, but we can identify some of what a trust structure accomplishes that can be identified or utilized in a relatively similar way. So we can, of course, look through the articles of the Civil Code to find some of that. And again, I won't get into this further, but additional research ultimately revealed that there are some issues, in fact, quite a few issues using this structure in Quebec, but that there are some workarounds, some tweaks that can be made to, by and large, get to some of the displacement avoiding results that were, located in other jurisdictions and other legal structures. Another legal tool drawing both here on international soft law frameworks for identifying and valuing cultural heritage, the right to culture, as well as a lot of legislation and policy that's been developed outside of Canada. So Australia, for example, with the Burra Charter, this was helpful in thinking through, identifying heritage as a much broader concept than the dominant focus in Canada, which has tended to be on tangible cultural heritage as the kind of epitome of the protectable thing. And instead developing an understanding of how intangible cultural heritage elements can be sometimes a valuable sole identifying factor for a protectable cultural space. And here in the common law context, we have the easement that can be useful. So specifically, heritage easement structures in common law that can be adapted in order to translate better heritage protection into local spaces in Canada. And this can be done along with some relatively small changes in the language or focus of local heritage bylaws, statutes, provincial heritage legislation. And we also have the conservation servitude that we can locate in civil law in Canada that can also translate some of what's expressed within the international soft law frameworks that I was looking at for valuing intangible cultural heritage in an equal manner to tangible cultural heritage, which again addressed some of the displacing effects that we can observe. So great, fantastic, but how? So how do we first focus in, at least broadly, on a defined problematic, a research question, a conceptual solution? And here we get back into this idea of looking underneath the law. And so let's back up a little bit here. So how do we get here? How do we identify a problem, the cause of the problem we've identified? And this is where sociolegal methodologies come in. And so here in my work, I draw specifically on my background in anthropology and archaeology. And because I'm looking largely within legal frameworks, looking underneath them, right? One methodological approach that really informs what I term urban legal anthropology, which I'm going to focus on next, is institutional ethnography. So I'll break down what this looks like a little bit more, but first in terms of some background, and this is what, if you had a chance to look at the DeVoe and McCoy piece, or if you want to revisit them, this gets into a description, kind of unpacks what I'm talking about here with institutional ethnography and what the application or methods of this kind of involve. But the point of it, of institutional ethnography, is to find within the quote unquote everyday world structures of power, ruling relations that the relations of ruling that shape local experiences. And so institutional ethnography is fundamentally driven by a search to discover how it happens, how something happens. So for example, how inequality happens in the everyday world as one kind of navigates their everyday life. So there's no one way, there's no quote unquote right way to conduct an institutional ethnographic investigation. So instead, it's an analytic project that can be realized in a diversity of ways. And another perhaps surprising aspect of institutional ethnographic investigations, and this can make applying, to be quite honest here, this can make applying for grants or writing proposals or applying for ethics clearance a bit complicated, is that institutional ethnographic investigations are rarely planned out fully in advance. Instead, the process of inquiry, the research itself, is part of the development of the project. So as DeVoe and McCoy describe, it's rather like grabbing a ball of string, finding a thread, and then pulling it out. So yes, it can be a bit difficult to define in advance exactly what the research is ultimately going to involve. You discover the next steps as you go. And, drawing on the famous words of Sally Engelberry, you really do become the research instrument. So as you go, in order to understand or explain what you ultimately want to explain or discover, you need to step by step discover, locate who you need to interview or what texts and discourses you need to examine. So the term ethnography here, where interviews are often used as an ethnographic method, interviews are used primarily for locating and tracing connections among individuals within a particular milieu or within a particular institutional framework, network of activities. And the goal with interviews here is to get informants to speak about a particular circumstance, not just to shed light on it, but also, again, to guide the researcher towards the next step in the research, to guide them towards crystallizing their research question, towards understanding the ins and outs of the question or of the problem. And interviews are much less of a central focus than one might generally assume would exist within, broadly a sociolegal methodology. So interviews here, again, are more part of the process to get further into the research than part of the data that ultimately might form the end product or the deliverable, right, at the end of the research. So interviews here, using that term in this sense, is even a bit too formal of a term in the first place for the kinds of interactions that institutional ethnography draws on. So interviewing in institutional ethnography is often really best described as, quote unquote, talking with people. And the use of interviewing here should be understood in this wide sense, and it spans a range of approaches that are used to talk with informants. And this range spans from planned interviews, kind of the more traditional way we might think about interviews, where the researcher makes an appointment with someone for the purpose of doing a research interview with prepared questions, to the other side of the spectrum, which is this informal kind of talking with people that can occur during field observations, when the researcher is watching someone do something, watching them, be in a place, and asks for an explanation of why are you doing this? Or, why have you made this choice? And how are you doing this? And so on. So these two ends of the spectrum can also be combined, of course. They can follow each other, they can enter a dialogue, they can draw on each other, build off each other. And on the informal end, these can also arise, in an entirely unplanned way. So as the researcher is themselves going about their own daily life in the city and just kind of keeping an open eye to what is going on. Of course, this depends on the topic of the research, but as you can see, this is very ideally suited to being immersed in understanding a process within everyday life within a city. And also this informal category of interview, of talking with people, of course, as you might kind of guess right now, doesn't necessarily have to be done one-on-one. But at the same time, neither does the interview on the more planned formal end of the continuum. So for example, a focus group that generates a group conversation about a shared experience, this can be an excellent resource too within that side of the spectrum. And the bottom line here is that interviews in institutional ethnography are much more than asking questions and listening to answers. So regardless of, where they're placed on this spectrum from formal to informal. Okay. So an example of this within some of my work, so thinking back again to the example I was giving about displacement of particular cultural venues, during one particular portion of the fieldwork that I was doing in Toronto, So yes, of course, I spent a great deal of time around music and performance spaces. You can see this one that's kind of in the process of maybe staying, maybe being displaced. So in these spaces around Toronto's music community, performance community, arts community. And I also spent a lot of time around the structures, or the human representatives of these structures, of the urban legal framework that was ultimately shaping the sustainability and the governance of these spaces of music and communities. I spent a lot of time listening and then following up on what people wanted to talk about, what they suggested. And I spent a lot of time observing the interaction between these two different camps. So, on the one hand, those more attached to the music spaces themselves, and those more attached to the governance of these spaces. Now, these overlapped a bit, and there were folks advocating for each other on either sides. And one particularly vibrant place for this that I was led to through the research process was a set of meetings that happened about 4 times a year in Toronto City Hall, and it was conducted by the Toronto Music Advisory Council, which was a body that operates about 4 years at a time before it's renewed. And so here are the different factions of stakeholder groups engaged within the music and cultural and performance spaces in the city would talk to each other. And they would engage with each other by being present in the space, in this meeting, to advocate for their cause, for their venue, or a particular issue. So ultimately, a lot of what my observation in this space was about was to listen to these groups, talk to, be a fly on the wall, listen to them, talk to each other, interview each other. And this was far more rich in data than any planned initial interview question I could have come up with and asked and individually interviewed people with. And these meetings really helped me to understand the layers of the intersection between music and performance spaces and communities in Toronto, not being from Toronto myself, and how they intersected with Toronto's municipal legal frameworks and development policies and documents and law in a very nuanced and efficient way as I was continuing my fieldwork in other sites in Toronto. So it really just placed me right into the middle of everything that would have taken much more time had I kind of followed a more formal interview approach. So in addition to these interviews, another central element within institutional ethnography is the role of text, text-based discourse and forms of knowledge. So texts, as we know, obviously form a huge basis of the legal materials that shape official legal systems. And text also shapes a lot of what we might identify as informal legal structures, so normative orders that function alongside official law. And texts, beyond these legal texts that we probably think of straight away, texts in institutional ethnography terms are usually really just some kind of document or representation that has a relatively fixed, replicable character such that it can be stored, it can be transferred, copied, produced in bulk, distributed widely, and plays really some sort of standardizing or mediating role. And in this sense, a text can really be any kind of document. So, whether this on paper, whether it's found on the internet, whether it's a PDF, it could also be a drawing, a photograph, a video, a sound recording. If we back up just a few slides here, it might be a development proposal that pops up on the side of the street that people interact with, as you can see here on the screen. So really, it's something, even a sound recording, again, that can be drawn from quite unconventional sources in order to track a variety of processes. Reddit, real estate postings, governance norms for the content of Wikipedia pages, if we think about the virtual context. But a large part of the utility of text in institutional ethnography is also about, again, the reactions of informants to text, like we saw on that slide, right? People reacting to the development proposal, enough, stop this. So how they react to these governing documents, and this is often more important than the texts themselves. So again, drawing on the music venue policy displacement context in Toronto, the reactions of musicians in the music and culture and performance communities to the policies and strategies developed by Toronto City Hall, purportedly, to address the displacement of music venues, et cetera, was really more important than the documents themselves. So what I thought I would, how are we doing for time here? What I thought I would do next is speak just a little bit about a project that I'm starting right now. So this is great, I'm talking about things that I've done, but what does this look like, when you start out? So we'll talk about that for a little bit and how I'm going to shape what I'm planning on doing in this kind of comparative, transsystemic, institutional, ethnographic, urban legal anthropology way. Okay, let's just get into that. Okay, so urban law at night. This is the broader problem, and the broader project considers, urban law and governance in the context of the 24-hour city. So specifically, the nighttime portion of this day-night continuum, as I describe it, and the objective is to, have sustainable redevelopment and spatiotemporal equality in cities. So the project is planning to look for what a well-developed legal infrastructure for the night, in particular, might consist of in a relatively replicable or transferable form. But specifically, this part of the project that I'm starting out with will look into law and governance surrounding late night food. And I'm beginning with Halifax because that's where I'm kind of doing my ongoing fieldwork. That's where I'm situated, right? And the fieldwork that led me to my initial insertion point into this project. So you can see that this is my string from a ball of yarn that I'm gradually pulling out. And so what this was, it was a conflict that arose last semester. And it was quite, prominent within Halifax, but also within the particular locality of the university. So this was a conflict that arose between the owners of two family-run corner convenience stores that also operate as late-night pizza places, hot food counters. And they're situated, again, near Dalhousie University. So that's where my law faculty is located. And these are oftentimes frequented by students at night, but there's also a hospital nearby. So, with people doing shift work and stuff, this is also helpful for them. But in terms of the students that frequent the space at night, it can be imagined that this can get quite loud in this neighborhood with this concentration of places. So local non-student residents complained to their local city councillor, and who I should say in kind of his other portfolios is quite an advocate for culture and gathering and community in the city. But so local residents kind of complained to this local city councillor, and the local city councillor dove into Halifax's applicable zoning bylaws and found ultimately that these two stores were operating legally, but they were doing so within a bit of a loophole, which I won't get into detail about, but it had to do with food and when it could be served and what kind of a business could operate and multi-use type of structures in the city. But essentially, the city councillor proposed a bylaw that would close this loophole across the city, and without really consulting with many of the stakeholders, but really relying on his interaction with the local residents who had kind of complained about this. But so this would affect all of spaces across Halifax, but ultimately the bottom line is it would really only affect these two stores, and it would take a large part of the business away from them that would make their operation viable. So as the store owners described, and they wouldn't be able to stay in business without this particular aspect of their business. And so here we have some of the key texts, that are implicated in this targeted attempt to close two family-run businesses operating at night, these bylaws and zoning matters. And but these businesses serve a particular portion of the city's population, right? And so this controversy led to all sorts of media hoopla and interviews of the different stakeholders involved, and also these interviews and this discussion back and forth shaped some of the guiding discussions for me to follow, and also generated a lot of advocacy discussions at City Hall, which led me to some further texts that were created by just one example is City Council's Women's Advisory Council at City Hall. And so what they've done is started an initiative looking at gendered approaches to zoning bylaws in Halifax, since women identifying individuals have been quite vocal about how having these two businesses open late at night in the neighborhood is very significantly important to the degree of safety they feel in the neighborhood. So as you can see, a lot of different moving parts come out of this one little news piece, if you kind of follow and pull out the thread. So these are some of the different stakeholders that I'll begin with. And now, simultaneously, this is another aspect too, and this isn't something that I've created, it's just to give you an example of what I'm talking about. But simultaneously, I'll start assembling a jurisdictional scan. So provincially, nationally, internationally, from ideally, right, in an assorted sample of civil law jurisdictions, common law jurisdictions, to look at how different cities regulate late night food, and kind of building out the different aspects or nodes that I'll look at for that. But as you can see, it remains to be seen exactly what direction this will take for me. In terms of the question of a well-developed and equitable legal structure or infrastructure for the night, what this would ultimately consist of in terms of food accessibility and regulation over the full 24-hour spectrum. So to be discovered, but such as gives you a little sense of what things look like on the front end rather than just the back end. So I think I'll end there and see if anyone has any questions about particular methods or projects or approaches or anything really.
Thank you very much, Professor Ross, for this wonderful presentation. I think that this has been a lot of methodology that you illustrated today has been extremely rich as a focus for us and for our further research. So I will start asking questions. If someone has a question, just you can raise your hand, or you can either drop it on the chat box.
Maybe I'll stop sharing my screen too, so we can chat more.
Yes,
Okay.
Vanessa, I think Daniel has his hands up.
Okay, Daniel?
I mean, please feel free to go first. I can also go after. Okay, never mind. Then I start. So first of all, thank you. I think this was super interesting. To me, I haven't heard about the methodology before. I have one comment and one question. So the comment is about institutional ethnography. For me, this was super interesting because I feel like that let's say the materialist critical studies of law, or everything under the umbrella term, maybe ideology critique, is kind of often in a problem because either they tend to become too fixated on discourse analysis, and therefore I would say kind of lose sight of the materialist premise, or probably because a lot of them are coming from high theory, they stay in the realm of high theory. So what was super interesting about me is that it tries to take the materialist premise to where I think it needs to be took to study the mundane everyday settings. So I just want to say I haven't heard about this before, and I thought this was super interesting. My question is actually about transystemia, and I think this what you described mirrored a lot what we have heard last week from Professor Sara when she talked about decolonial comparative law, is basically challenging us legal scholars. Where are we normally looking at when we study law? But as I understood it, you presented this as a challenge, especially to comparativism. But then a lot of it was, to me, a legal realist challenge of maybe what the law is. So I would be interested in how you think this is particularly an intervention. I mean, if it is, right? But particularly an intervention for comparativists or the method of comparing.
Yeah, thank you. I absolutely agree, right, with really the point of institutional ethnography is, just to address your first point there, is oftentimes described as sociology for the people. And so really looking at these mundane aspects of the everyday that are often overlooked. And no, that's not to say that high theory doesn't have a role. It's just kind of that sometimes, if we apply high theory, we start up here and then we try and get down to, what a problem is. But it's also possible to go the other way, right? So you'll see some great projects that start out at this really nitty-gritty, mundane place of, a little annoyance, right? Or something that that you've caught on or you've found, or that is really creating a source of trouble for people. And then you can build this back up too. So it's an interesting dialogue that can be created right between this kind of low theory, high theory, if you want to call them that. And then, so for kind of thinking about comparativism and transsystemia, absolutely. So if we kind of delve into, and I didn't go into, more too much of this from of legal pluralism, but really what we are talking about here is this question of what is law. And, and this is a whole other discussion, right? Of, what are we comparing and what can be compared if we're doing comparative law? What is law? And this has, many different opinions of, what law can be. And of course, some of the criticism, if we really go into, full on legal pluralism, we can start to see the law in everything. All sorts of informal systems that govern everything we do, habits. We could find law in everything. So that's sometimes criticized as a danger in thinking about legal pluralism and comparative law in this very broad sense. So that I think, and I don't think it's necessarily a problem. I think it's just something to be aware of, right? That, do we want to have that open of a conception of everything being law, or do we want to kind of curb that a little bit? But yes, really, we are getting into this question of what is law and what can we compare. And I do think that there's, from this transsystemic approach, a value to kind of thinking much farther beyond what we conventionally understand as legal systems, and beyond indigenous legal traditions or anything. I mean, law comes from somewhere. The rules and everything that structure our lives, they come from somewhere. And sometimes these informal norms and things that we wouldn't necessarily consider to be the subject of law or legal material eventually can actually become part of these more formal systems. So I think there definitely is this value to really playing and thinking about these different conceptions of what law can be.
Thank you very much. Are there any other questions?
Yes.
So then I'm going to, yes, Simon, go ahead.
Yeah, no, thank you, Vanessa. Instead of a question, it's more like a comment and a reflection of what you said. In law science, we invited Professor Chao Sitong, who is currently a Duke Law professor, and I think his point of view was driving from in China, what is considered as law would be there is like a difference between what is law and what is not law, or how do people organize themselves. And so when he was delivering his lecture on comparative Chinese law, that was some angle that he also kind of drew upon. But yeah, I really enjoyed your methodology, and I felt like these several sections kind of resonate with each other, and I think those are very important questions, which is like, what is law and what can we compare with?
Yeah, thank you. And I think, part of really, I started out talking about the importance of quote unquote writing it up. And so, despite, thoughts of how we interpret law or think about law, or what methods we choose, part of the truly important thing is describing what we're doing. So describing, oh, I consider this to be law because of, and thinking about in the same way that, as law students, we always want law students to give their because. And so the same thing applies for, considering what is law, or the methods we're applying is this transparency that we can include in what we write, that I think can really build out our understanding of what law can be, or what methods can be used for in law. So just kind of to put that plug in there too for writing it out. And replicability, honestly, is where we get to with that.
Okay, so I'm gonna take moderator privileges, and Yeah, I have a question, comment, actually two questions. The first one is regarding your approach to ethnography and labeling it as an alternative sociology. And what I see after this presentation of this intersection of interdisciplinarity, because I don't see only comparative law or only ethnography, I see also fieldwork, which could be done within anthropology or other type of studies. And it seems to me that it's much more in line to the law and society movement, to understand social norms and to understand that the law legal problems are a product of human conduct and human development. So I would like you to elaborate a little bit more on that, why you think that is alternative sociology, and if you are thinking just only on social norms or what you're understanding in that part. And the second one, though, is much more dry, and it's on the section that you were comparing trust law and comparing it within civil law and common law countries, which to me has been, I found it really interesting because trust is really an institution of common law that comes from equity. And for years and years, and when I started my, after I got my law degree, I worked on trust law in Italy. And so I was also trying to understand how trust law can be put into Italian regulations, but it was almost impossible because trust it's only an institution from common law. So importing trust law into a civil law system needs some adjustment, especially entering the realm of contract law, which obviously is not trust then.
Yeah, thank you. So first of all, to talk a little bit about law and society, yes. So I mean, full disclosure, my kind of my alliance is really with law and society, and that's one of the reasons when I decided I wanted to do my PhD. It was really quite the driving factor behind that is having discovered law and society as something that I could really connect with. So yeah. I find that it's helpful, and you'll often find me at the conferences. I truly love listening to how everyone is thinking about field work and how to engage with law within this context of society in many different ways. And really, I think the idea of interdisciplinarity and law and society are so intimately interwoven for me. So definitely, I think that this really does speak to law and society, and that's oftentimes where I'll find a great kind of community to talk about this work with. And one of the reasons why I like it is, the law and society. So you have folks who are coming from law and who approach kind of primarily through the legal lens. You also have folks who, approach primarily through the lens of the social sciences or kind of start with society. And one of the reasons why I really appreciate institutional ethnography is I think it really kind of encompasses this law and society aspect that I'm interested in. And because, law, as I was saying, is so fundamentally influenced by texts that this focus on text that you might not always find in other kinds of, approaches to ethnography or in uses of field work in interviews is quite unique and quite important because, again, I'm really interested in this law aspect within society. And in terms of the alternative sociology, so that kind of has a bit of a larger, background than me thinking about it in that sense. So institutional ethnography was kind of pioneered by Dorothy Smith. So if you're interested in it, that's kind of the grandmother of this. And so she turned it an alternative sociology to try and think through a lot of ways of approaching sociology from a feminist perspective, where there had been kind of gaps that she'd identified in the past. So in this sense, alternative sociology not only talks about kind of thinking about field work and what we're talking about in this different way, but also approaching it from a lens that uniquely could get into some of the issues that women were facing within institutions, and teasing out the minutia of where these inequalities were happening within texts, within interactions based on text, and how that kind of structured the everyday experience of a woman in an institution or in healthcare or aspects like that. So that's a little bit of a background to this the term kind of alternative sociology that I will just directly attribute to her work. As for trust law, yeah, exactly. Now, as I kind of alluded to, thinking about how we could achieve some of what a community land trust, harnessing the trust structure in property law and common law property can do, and thinking about how to locate that in civil law was very, very complex, and had quite a bit of challenges that I encountered, that I think people continue to encounter. And I won't say that there's a solution or an answer precisely to how it can be used or found or located within civil law. And of course, part of the whole point of transystemia is that we're not necessarily trying to locate the trust, right, within civil law. But really, I think within civil law, it's really a matter of looking individually at each civil code and how it's being interpreted. So, within civil law, we don't necessarily have the benefit of, or we don't think about precedent in the same way, right? But you can still, of course, look through decisions where they're accessible to kind of see how similar solutions or outcomes are being sought after or looked at. So really, and if you remember from my very quick journey through those slides, ultimately what I was able to do within Quebec was to look at 3 specific codal articles and tease out a lot of how we could locate some of the essence of what we were achieving with the trust in common law within those articles, and looking at the annotated version of the civil code and seeing what decisions had been engaging with that. So specifically in Quebec, what I found to be very useful was to look at a lot of kind of progressive decisions, I'll say, dealing with environmental law. So protecting parks or protecting certain natural aspects. So not buildings at all, not at all the context I was looking at, but where some of these codal provisions had been interpreted to be able to protect natural habitat within a loosely understood kind of what I would, if coming from putting on a common law hat, say, hey, that looks a little bit like what a land trust might look like in common law. So again, I think I don't think you can find the trust, right? So I totally appreciate what you're saying about the Italian framework, but that teasing apart the codal provisions and the interaction with codal provisions that decisions have and that legislation has, you can sometimes find a little bit of what you're looking for. And for me, for this particular context, I found that in decisions relating to or how these articles had been applied to the natural context and the environment.
Thank you very much. I think this has been a fascinating presentation. If there are no questions in the chat or hands raised, I think that, okay, we thank you very much for being here today for this wonderful presentation. And we're going to proceed to taking some pictures for our social media. So, Simon, are you going to open it?
Yes. So everyone, please turn on your camera. Thank you again. Thank you very much, Professor Ross. Let's take a picture together. You can put it on our social media and just turn on your camera, and I'll direct everyone. All right. So 1, 2, 3. All right, let's take another one. I see Christopher just turned on his camera. 1, 2, 3. Fantastic. Well, thank you very much for joining.
Thank
Back
you.
to
Thank
Vanessa.
Thank you very much, and hope to see you all next week. And thank you, Professor, again for this wonderful presentation.
Of course, it was my pleasure. Thanks, everyone. Have a great weekend.